evening based on where you're joining from. And welcome to the Legal Tech Unfiltered Episode 1, the Mediators Conclave, brought to you by Presolve 360. Presolve 360 is India's leading online dispute resolution platform dedicated to making conflict resolution faster, more efficient, and accessible to all. By combining technology with the human touch of trained mediators, we help individuals, businesses, and institutions resolve disputes hassle-free and efficiently. Resolve 360 is proud to present to you this unique digital knowledge exchange, which brings together three very special guests. I once again welcome you all to this very special webinar, where we explore the fascinating intersections in the world of mediation. Today, we'll be hearing from our distinguished panelists from three jurisdictions, India, the UK, and Turkey, on three powerful themes: the dichotomy between mandatory and voluntary mediation, how technology and the human touch intersect in the mediation process, and what ultimately makes mediation a life skill. I'm Namita, your moderator for today, and it is my privilege to guide us through this rich conversation. We have a truly international panel bringing not just legal expertise, but lived experiences and cultural perspective. Today we have with us Mr. Mustafa Mert, Mr. Rahim Shamji, and Ms. Tanu Mehta. A very warm welcome to our panelists.
Thank you.
Mr. Mustafa Mert is a Chevening scholar and international dispute resolution expert with extensive global experience. He is the resident representative for Turkey at ADR/ODR International and currently a senior associate in the dispute resolution department of Pekin Bayar Mizrah. Sir has served on the executive board of the Istanbul Bar Arbitration Center and spoken at major international arbitration forums. Matt, sir, thank you so much for being with us here today.
Thank you so much for the kind invitation and for the kind introduction, actually. It's a pleasure to be here today among such distinguished colleagues.
Thank you, sir. Mr. Rahim Shamji is the founder and CEO of ADR/ODR International, an international mediator, educator, and speaker with extensive experience in bringing cultural and geographical divides in conflict resolution. He also serves as chairperson of the Board of Trustees for Focus Humanitarian Assistance Europe and is a fellow of the Civil Mediation Council UK. With a strong background in international law, negotiations, and trainings, Sir combines cultural intelligence with practical expertise to design innovative dispute resolution processes that work across diverse contexts. A very warm welcome to you, Rahim, sir.
Thank you very much, Namita. Lovely to be here with you and Mustafa and Tanu. Feels like I'm being with friends.
Thank you, sir. And Ms. Tanu Mehta is a seasoned legal professional, mediator, and arbitrator with over 25 years of experience in constitutional and administrative law at the Bombay High Court. She is the former honorary director of the Center for Mediation and Research at MNLU Mumbai, chairperson of the Committee for Mediation and Conciliation at the Bombay Chamber of Commerce, and co-founder of the Association of Mediation Practitioners. She is also a mentor to Presolve 360 and continues to guide initiatives that promote mediation and alternative dispute resolution in India and globally. Thank you for joining us today, ma'am.
Thank you so much, and it's so exciting to be with Mert and Rahim, both friends and colleagues at the bar.
Thank you so much. I also extend a warm welcome to all the participants who've joined us today from across the globe. We only have one housekeeping rule for today. Please ask lots and lots of questions. You can share your questions in the Q&A section and I will request the panelists to address them after our discussion. Mediation has always been a space where law meets humanity. Today, we'll ask tough questions, challenge assumptions, and hopefully leave with answers that go beyond the black and white of legal frameworks. So let's dive in. Let's start with a question that sparks debates in boardrooms and courtrooms alike. Is the best mediation the one you choose or the one you can't avoid? As mediation increasingly becomes a mandated step in legal systems like in India and in Turkey, we're now seeing a growing trend towards making it a mandatory pre-litigation step in certain types of disputes. While this aims to reduce court backlogs, and encourage early resolutions, it raises a fundamental question. Can mediation remain a voluntary party-driven process if participation is legally mandated? How can we still design and deliver this requirement in a way that still respects party autonomy, and nurtures voluntary, meaningful participation? My first question is to you, Matt, sir. According to the mediation law in Turkey, before a case proceeds to court, parties in commercial disputes are required to participate in a mandatory mediation session. Similar is the case in the Indian mediation framework as well. How can then mandatory mediation be thoughtfully implemented to build self-determination in dispute resolution? Over to you, sir.
All right. So once again, it's a pleasure to be here today and speaking to you together with the distinguished colleagues. So first of all, I would like to start a little bit about the legislation in Turkey. So I assume you are not all very familiar with the Turkish legislation. That's why I would like to give a broad overview. And starting with the legislation, I must say that the main source of legislation, which organizes the issues around mediation, is the law on mediation in civil disputes, and this code is numbered 6325. So the first article of this code says that this law shall be applied in private law disputes arising solely from the affairs or actions on which the parties may freely have a disposal, including those possessing the element of alienage. However, disputes containing domestic violence are not suitable of mediation. So that was the primary law. And as the time moved on, the Turkish legislator moved on as well and introduced new laws which made certain areas of dispute and certain areas of law into mandatory mediation as well. So one instance is the employment law, according to which disputes in relation to the employment receivables are subject to mandatory mediation in Turkey. Next, they also introduced a new law, and after that law, now all commercial disputes which are related to the collection of a receivable, basically debt issues between the parties in commercial backgrounds, are also subject to mandatory mediation. Following that, they made some new regulations, and other types of disputes, such as the consumer law disputes, are also subject to mediation, mandatory mediation. Finally, some other areas which are subject to mandatory mediation are, for instance, rent disputes or the sale of the properties which are jointly owned by the parties. So over the course of time, we see that there's an expenditure in terms of the areas of law that are subject to mandatory mediation. And there's a reason to this, which is basic, and it is the increasing caseload of the courts. So basically, this is the strategy of the judiciary to decrease the caseload by also like making parties come into settlements under mandatory mediation. Personally, I'm not 100% in favor of mandatory mediation. For me, again, it's my personal view, I think mediation works best when it's voluntary. Because when you force people into mandatory mediation, then people might think, okay, the system is just denying me my day at the court, or this is just a step that I have to like overcome in order to litigate. So personally, I believe the mediation works best when it's voluntary. And in another aspect to look into this issue is this is just an additional income for the lawyers, because there's an inflation in the number of lawyers as well. So people are like really concerned about their income. So they introduced this mediation, mandatory mediation, and then they opened exams for the lawyers to become mediators. And this is an additional income for the lawyers as well in that sense. So this is the basic overstructure, the legislation, and how it pans out. Basically, the government is very happy about the numbers. They also like present these numbers about the success rates. Personally, in my cases, especially when I'm representing the employer, I'm talking about the employment cases at the moment. Basically, employers don't want to settle because once they settle before a mediator, then the word gets around, even though it's confidential. But then all the employees at the factory start to say, okay, this company is like handing out paychecks, so let's sue the company. Oh, we cannot sue, we have to go to mediator, and then we will have these like confidential mediation agreements, and then we will get our paychecks. So basically, in my sense, this is like a way of the government trying to tackle the caseload of the local courts, and there should be some other mechanisms to make mandatory mediation more favorable to the parties. One could be like considering the inflation rate in Turkey, also the devaluation of the Turkish lira as well. And when you also consider like how many years a single case takes, the duration of a single litigation is pretty high, ranging from 3 to 5 years in local courts. And also there are like 2 other appellate levels. So considering this, in many of the cases that I'm working on, parties are more keen to settle with the opposing party. So that could come into play, and rather than like mandatory mediation, I don't know, like maybe introducing a new system in the middle of the litigation, like maybe like offering parties to settle once more throughout the life cycle of a dispute could be more beneficial in that sense. So that's how I would like to start this discussion, and I would like to contribute more throughout the way as well.
Thank you so much for sharing how Turkish laws work with respect to mediation and your unique perspective on how this probably needs some realignment. I'll base that for the next question to our next panelist. Rahim sir, for you, from your experience leading complex multi-party mediations globally, how do you think jurisdictions like India can structure mandatory mediation in a way that still honors the voluntary spirit of the process?
Thank you, Namita. It's a really good question to kick off because, as you know, the work that I do with the team around the world, there are many, many countries that want to implement a form of mandatory mediation. And my starting point for everyone listening is mandatory mediation does not equal mandatory settlement. So we have to be clear that there must be a route that says, have a go, have a meaningful go. And if that doesn't work, then the courts are available. And you may not know this, but it was many years ago, probably 2010, 10, the province of Ontario tried to make mediation mandatory in personal disputes, so inheritance, etc. And there was no escape, as I called it, to the courts. And the law did not make it onto the statute books because the people of Ontario resisted this idea that you're forcing us down one road. So to your question about the voluntary nature, I think we have to accept that some things are good for us in life, but it's how much we put into that, what we get out of that. But we should allow people that journey. The second thing to think about on this question, as India moves this way, is there are 2 models coming out from different parts of the world on what mandatory mediation could look like. And so you have the Italian, the Turkish, the Greek model, as I call it, which is called the model where the individual is, how do I put it? They have to file first before they can go forward. And what's coming out of the UK and what's coming out of Spain is it's not about even filing. This is a pre-action type of mediation. Now, those 2 models have a slightly different feel because one says only when you come to court we mandate you, and the other one says you can't even come to court until you've had a go. Then the court remains open. And it saves you a lot of money and stress, etc. And I think that India has to make a really big decision Because if it goes down what the British and the Spanish are going to think about doing, which is pre-action, you need a lot of regulation in place and standards for that to work. And in my experience of working in India, India likes a lot of regulation and a lot of, not red tape, but it wants to make sure it works well within the framework of a court system. Then I think it has to go down the road of the Italians, the Turkish, the Greeks. But I would just warn one thing, that awareness needs to be created amongst the users in a way that has never been created before. And the Italians, the Greeks, they really struggled because the majority of people didn't know what mediation was. The word mediation wasn't used regularly. The idea, and even if you think about what's happening in India, which I commend, it's fantastic that we have the Act, the Mediation Council, it's still only known amongst the lawyers and the mediators. The vast amount of people really haven't understood this. So we need a strong awareness campaign, no matter which mandatory road India takes.
Now, thank you for sharing global perspectives and how we have to look at Indianizing it for what would work here. How laws, awareness, people, public, judiciary, everyone can come together to make that happen. And on that note, Tanu ma'am, to you, building on to from that, as you know, in India, parties are required to attempt mediation before taking certain disputes to court. Based on your close work with the judiciary, with policymakers and mediation institutions, how can such mandatory mediation be still implemented in a way that encourages genuine participation without taking away the spirit of mediation and still protect the party's self-determination and remain true to what mediation is meant to be at its core? Ma'am, you're on mute.
Okay, so first of all, thank you for this question, and thank you so much, Mert and Rahim, for your perspectives on a similar question, because it just kind of provoked me into many thoughts. The first of which is that mediation has to necessarily mean voluntariness. I do not think mediation can be even attempted without first accepting the voluntary decision making of the parties. I mean, that has to be a no-go. And I think everyone understands mediation to be that, primarily because it's not authoritative. I mean, it's not coming from authority. The decision will ultimately have to be with the parties. But how you lead that mediation, how you lead that discussion between the parties, which primarily empowers them to not only take decisions, but to follow up with them, with their decisions. I think that is the key, key to all good mediation. Therefore, mandatory or non-mandatory, because I have to tell you this, that Indians have been in a position where actually originally they only went through mediation. We did not have a court system till the British came in. Okay. And once they moved to court, we've not had mediation again. I mean, mediation has been trashed like a completely, useless process. So now giving statutory importance to mediation and bringing it back to the masses, I think Indians will accept it well. But my real fear is that we do not have good trainings for mediators, and we do not have people who can actually, mediators who can actually grasp the fundamentals of good mediation. So, in my view, the whole situation hinges, the success of mediation hinges on good trained mediators who will lead the process. And whether it'll be accepted, unaccepted, I think that we can leave it for later years to prove. But I think India is not going to, India and Indians are not going to dump mediation once it comes in either as mandatory or either as a preferred mode of dispute resolution. through regulation.
Thank you for that. We're hearing wisdom from across the world, different cultures. I think goal is still common, an amicable resolution. Before we move on to the next question, I would request the participants to share their views by way of a poll. So if the poll could be put up on the screen, and then we'll move on to the next theme. Okay, I will move on to the next theme. One thing is clear that whether mediation is chosen or mandated, the process today often has a new co-pilot, and that's technology. Let's turn to how technology and human touch intersect. The digital shift in dispute resolution, accelerated by necessity and innovation both, has expanded across an efficiency in unprecedented ways. But as we lean more into technology, there seems to be an equally pressing need to preserve the human connection that makes mediation so powerful. How can then we design ODR environments that are efficient as well as empathetic and inclusive? And how can dedicated ODR institutions and robust training programs, as ma'am you mentioned, help mediators to build the skills needed to maintain party trust and connection in digital formats? Matt, sir, my question is to you. What lessons from Turkish mediation systems do you think India can adapt to accelerate a future facing ecosystem? What are some of the best practices in your experience that you have seen in integrating technology into mediation in ways that elevate and not replace the human connection?
So I would like to share two practices, and then we can discuss whether you have something similar already in place in India or not. The first one is the digital system that we as lawyers and also mediators are using, which is called UYAP, which can be translated into National Judiciary Network Platform. So basically we have this platform where the mediators first record the case there, and then all of the developments are recorded there as well, and then all of these systems are integrated, so a court judge can also have an access to that system once the case file translates into a litigation if the parties cannot come up with a settlement agreement. And then all of these systems are integrated, and it's a huge relief in a way because you can basically trust that the system is working well. All is recorded. No one is like tampering with the evidence or with the documents. So it's all out there. Still, it's based on confidentiality. So only related parties have access to it. So this is a huge relief in a way that it makes our lives easier. So we can just, at the end of the day, electronically sign the settlement agreements and all other related documents and share with the mediator, and then the mediator uploads those documents to the system. So it's a huge it's a huge relief in that way. And the second one is the increasingly becoming popular as well, the overuse of teleconferencing systems or the online mediation, which also includes online hearings as well, but I would like to stick with the mediation in that case. So this is actually one of the few things that pandemic did in a good way, because before the pandemic, all of those mediation meetings were taking place in person. And since in mandatory mediation, it is not mandatory for the parties to attend to those meetings, we were just like sitting like lawyer to lawyer, face to face. And if my like client just wanted me to reject their offer, then there is no point of driving all the way to the mediation center and then losing half a day maybe. But since we have this increased system in terms of the teleconferencing or like online mediation meetings, it's a huge relief in that way as well, where we can just like have these like 5 to 10 minute discussions. And if the parties are willing to settle, then we can always come face to face with the participation of the client as well. But if not, then we are just like, okay, we are lawyers, a bunch of lawyers sitting in a room. The mediator is a lawyer, the opposing party is a lawyer as well. So there's no need to waste much of a time. And this is a huge development in that sense as well. We can always, like, as I mentioned, sign the documents with electronic signature. So all of these like developments in terms of online dispute resolution is happening around us, and it's increasing. I mean, still sometimes we have the governments interjecting in a way and saying that these mediation meetings should be face to face. But at the end of the day, mediators are also like handling those type of situations and needs of the parties in a way where, especially if a case is sensitive, they're having this face-to-face meeting. Whereas if the parties, it is clear from the beginning that the parties are not going to settle, then it's just like an online meeting for 5 minutes, and then the minutes are signed electronically and it's done in 5 minutes. So it increases efficiency a lot.
So from what I understand, you're saying is that firstly, there is a system that integrates mediation and then moving on to litigation in case the mediation is not successful, and which is also integrated with courts. I think that's an interesting perspective on how both can be bridged, and the starting point then for litigation shouldn't be zero, but can pick off from where from where mediation has ended. So thank you for that perspective. And then what I hear you saying is that mediation tools, I mean the online tools, can be used by mediators to gauge interest, to gauge the direction in which that particular mediation is headed, and then take it off from there, thereby making the entire process more efficient. So I'll base off my next question from there, which is let's hear about the UK perspective from Rahim sir. You worked extensively with digital mediation and way before ODR was popular. What techniques or innovations have you found most effective in preserving empathy and connection in an online mediation setting?
Oh, that's a good one. You know, when in 2015-16, I began talking about ODR and mediating on a video platform, you know, pre-pandemic, most people said to me, how can you replicate the environment of in-person into a video conferencing system? And I said to them at the time that each mode or each platform has a different skill set, number one. So the idea is not to replicate a physical in-person feel where you can share biscuits and tea and so on, but you find another way where the online world allows for that empathy to take place. And you've probably heard me say this, Namita, a few times, and Tanu and Mustafa, actually, in the last couple of years. But I'm a big fan of people understanding digital vocabulary and digital empathy, because I think these are different ways of communication. So when Zoom started, there were no emoticons, there were no emojis. You can now use emojis. You can now do different things. There is the ability to enhance the way you look on a screen with different cameras. Your sound can be clearer. I think there are lots of tools, but we have to accept that digital empathy is not the empathy of being physically present. We shouldn't compare the two. They're two different things. It requires us to have a different skill set. And the second thing that's happened since 2015, and now 10 years on, is the users of mediation who are digital natives, and you've heard me speak about this before, not the digital immigrant that I am, but digital natives, their understanding of online and empathy is not that this empathy is less, because they're used to this being a default empathy. In the pandemic, they were able to communicate and give virtual hugs, talk to people in a way that gave them comfort without being physically present. And I think that those two factors tell me, and the UK is embracing this role of technology. I think AI, this human experience of learning and talking to you, has really changed everything. I mean, I was using ChatGPT 5 this morning, And it spoke to me like a colleague was going to speak to me, and it really freaked me out. Like really freaked me out. So I think we're moving, and I think we just have to accept that there are different experiences for different platforms, in person and online. But that doesn't mean it's any less. It's like shopping online, right? When we did it in the beginning, no one liked it because either it was like the size isn't fair, or the fruit that you ordered didn't have a long shelf life because they give you too ripened fruit, etc. But you know what? For some things, online shopping is perfect. For some other things, you have to go in person. You know, buying a bed, buying a sofa, you've got to try it. Is it bouncy enough? Is it too hard? Is it too soft? And so I think we're going to get to a place where we won't realize that this is less or more. We'll just know these are different things happen.
You bring up very interesting notions. I understand what you're saying by talking about the concept that digital empathy does not mean replicating physical empathy. It's empathy in a different room altogether, in a virtual room that is native to that room, and how we build from there rather than looking at a comparison matrix between the two. And also that digital natives, which we all already are and are becoming, empathy is born already. We just have to recognize it and grow it further. And thank you for that example also that makes it very relatable with respect to shopping and highlighting that some require physical shopping, some require virtual shopping, and both have their own place, but one does not take away the experience or make it less in comparison to the other. And I'll use that as the base for my next question. But I've understood one thing, that beyond screens and softwares lies the heart of mediation, that is human connection. And let's explore on how we can keep that alive, no matter the setting or the mechanism that we choose. Tanu ma'am, for you, from your perspective, how can we design ODR experiences that don't just replicate, as Sir also said, any physical processes online, but they actually enhance party connection, they enhance dignity and agency through thoughtful use of technology? In your experience, what role can structured ODR platforms and well designed training and certification courses can play in equipping mediators to preserve this empathy, engagement, and party dignity in digital environments?
You know, I am very much of the view that there are certain things that are organically, uh, they grow organically. We are now in this new world of digital age, and especially, like you're saying, the ODR platforms, and we are trying to connect to each other online. Now, human beings being human beings, we will always uh, emotions will always come up with every situation. I mean, our children, get angry when they see certain animation, when they play certain games, they get emotionally involved. So every digital platform evokes emotions. Okay. When you talk of how can we design platforms that will evoke emotion, firstly, I feel everything will evoke emotion. There is nothing that cannot evoke emotion because human beings are emotional beings. Secondly, the science of evoking the right emotions is not yet perfected, even in actual world. In actual world too, like we've learned all the time, perspectives, words can have different meanings to different people. You could portray a certain gesture and it could mean different things to different people. So that is an evolving science. I mean, we still have to master that absolute perfect uh, science where a communication is taken for what it is. Communications can be perceived differently. Communications can evoke different emotions. So while we can all still try, that trial can only happen via interface, right? Because unless you talk and communicate with different people across the ODR platforms, you will not know how that person is receiving a certain uh, communication. So it's an evolving process. We can design as per cultures because that's a part of mediation training, how to be culturally sensitive. It's a part of mediation training, how to be open and alert to different perspectives, to different emotions that are coming through. So we have to basically, we have to be alert. We have to keep our antennas up, and at the same time, continue accepting and evolving in our journey on the online platform. Where it will take us, I don't know, but I'm equally not at all, I'm not at all of the view that we are people who cannot move on to this new world. Human beings have always evolved, and we have come to ODR or online platforms primarily because we weren't so efficient in one-to-one communication. I mean, personal communication. So, all the better. Let's move ahead.
No, you put it in such an interesting way, by saying that firstly, every system already evokes some emotion. We just have to figure out how it evokes the right emotion. But I also found it very interesting when you said that even in-person proceedings or in-person communication, we've still not perfected that. Then why are we holding digital communication in different light? We will perfect that also with time, but we will get better at it and it will still continue to evolve. We just need to adapt it to the settings and we need to keep learning and growing just like how we do for in-person communication, which I think makes physical communication and digital communication also in a sense at par, that both need work and both need to be adapted to what we want to say and how communication can then be effectively translated. And sir, when you talked about a GPT talking to you like a colleague, one thing also is clear that somewhere we still need empathy when it comes to mediation, which also means that in a way the future of mediation is not one versus the other, just like it's not physical versus digital. It may really not be man versus machine. It can be man with machine to give best outcomes. That could probably be how we see mediation in the future also. And on that note, we'll translate into another important area and widen the lens because mediation is just not for the table, it's for life. But before we move on to that, let's hear what our participants have to say. And I request if the team can again put up another poll. I'm going to take insights from mandatory versus voluntary, technology versus human, to move on to something which is the heart of mediation. Mediation is often seen as a legal or a professional tool, but at its heart, it's a way of life, it's a way of thinking and engaging with others. As the world becomes more interconnected, the values embedded in mediation, that is, empathy, curiosity, and constructive dialogue, feel more necessary than ever. That begs the question, how is mediation evolving as a mindset and a life skill beyond the legal field? What role can it really play in everyday interactions, and how can we cultivate these skills more widely across society, especially among young people and future change makers? How can we look at mediation as dispute prevention more than just dispute resolution? And on that note, my question to you, Matsur, is drawing from your mediation work in Turkey and across international jurisdictions, according to you, what untapped potential do you see for mediation in sectors beyond the legal field?
Okay, I'm going to answer this question both in terms of the sectors beyond the legal field and also another sector which is still in the legal field. So the sector beyond the legal field is the political issues. For instance, currently we have a lot of disputes around the world, a lot of countries going into war. For instance, what's happening today in Gaza, in Palestine is totally unacceptable. What is happening today in Ukraine is unacceptable. So still, I believe that these situations could be improved if more countries would act as mediators among those disputed countries. So I would recommend we should try to increase the dialogue rather than the dispute, and most of the political disputes could be resolved in a meaningful mediation section. So that's the sector beyond the legal field. And also still, I would like to contribute to this dialogue with another perspective, maybe which we haven't thought of before. I believe mediation can work pretty well in the energy sector as well. As the Vice Secretary General of the Energy Disputes Arbitration Center, which is an specific arbitration institution specified on the energy sector and the energy disputes. The Energy Disputes Arbitration Center also established a mediation center, which is the Energy Disputes Mediation Center. So the main purpose of this center is to resolve disputes that are rising in the field of the energy sector through the mediators that are experts in the field of energy. And in this way, they are trying to increase the efficiency, the speed, and lower the costs. So basically, if the parties just add a simple mediation clause to their agreements and name Energy Disputes Mediation Center as the institution, and also choose the energy the mediation center's specific rules in that sense, it could also work in their favor because established in 2017, the Energy Disputes Mediation Center has already delivered more than 24 workshops, and they also prepared a huge booklet and presented it to the government to be used in specific workshops to be delivered in the future as well. So there's a huge experience in that sector, and that could be used more efficiently, considering that we have many energy disputes and there will be many more, considering the region, considering the climate change issues, and also on. So mediation can be used both in those sectors. And again, sticking to the legal fields, actually, but I would say in most of my current disputes, the parties would like to settle more than ever. Because as I mentioned, there's an inflation issue, duration of the cases, the interest rates, and also the commercial needs of the parties. So for instance, just this year, I actually encouraged the client to go to mediation, the voluntary mediation, and we settled a case which took for more than 17 years now. And at the end of the day, all of the parties were thanking me because they thought this dispute would go on forever. But now people are more willing to settle their differences before a mediator. And I should also add that the settlement agreement signed by the mediator and also together with the accompanying lawyers is deemed to be as powerful as court orders. They are directly enforceable. And for also like international ones, you can always refer to the Singapore Convention, which is like the brother to the New York Convention in that way. So there are many sectors, even beyond the legal field, as I mentioned at the very beginning, the political disputes. So basically, mediation is a life skill. You have to be a very good mediator, even in your daily life. So there are many other sectors around the world which can benefit from mediation as well.
So, what I hear you saying is that some of the biggest conflicts that globally the world is facing can be resolved through dialogue and through mediation, and that we rather increase dialogue rather than dispute, and mediation is the way to do that. And also, thank you for sharing that example of the energy dispute, which 17 years and mediation could give an amicable resolution to parties that otherwise thought forever was still a short time for that dispute to be resolved. So, thank you for sharing that. And I'm going to base my next question on that. I also am curious about how this looks in different contexts. So, Rahim sir, you've led complex cross-cultural mediations across the world and across jurisdictions. Through that experience, it's clear that skills of a mediator go far beyond just resolution of that dispute. So, how can mediation skills like empathy, curiosity, maybe reframing become tools for leadership and for conflict prevention, just not conflict resolution? How can we train all individuals to use that resolution focused mindset right from schools, at homes, and in communities just as a way of life, not as a legal strategy for dispute resolution?
Mm. Really good question. And here in Bangladesh, when I've been doing a bit of training, I've been talking about this idea that mediation skills are now seen as human-centric skills. this ability to connect with other human beings and being able to listen and understand and empathize, show curiosity. And several things are happening around the world in this international space, which are encouraging and interesting. And I would encourage anyone, lawyer, non-lawyer. But it's only in the recent 30, 40 years that mediation has been hijacked by the legal community, right? But mediation in the workplace sense, in interpersonal skills, in family disputes, inheritance disputes, and I don't want to call the disputes legal, but just not being able to see eye to eye. These have been around for a long time. We have seen a rapid expansion of peer mediation, where children mediate children's disputes in schools and playgrounds, and it's become really sophisticated. In the south of France, the authorities in the south of France have one incredible peer mediation programs where kids have special uniforms and they help people to resolve disputes. But all of this, and I would encourage all of you to look at this, and I talk about this a lot in my training as well, is we need to understand something like what the Finnish government did, which is called the National Action Plan on Mediation. And when they presented this paper to me in New York in 2012, it was like a scroll, which is an architect's drawing of a building. And I was trying to get my head around, and I said to them, I'm so sorry, I'm not an architect. I'm a lawyer and a mediator. And they're like, no, have a look again. And there was one line that was going all the way through. And it was the line of a human being's age. Born 0, let's say die 100. And across that one line were different lines. And they had mapped every possible conflict that a human being might encounter from the moment they're born till the moment they die. So for example, if a child is born and has some congenital heart problem, and the parents say for religious reasons, no surgery, but the doctor's saying, look, it's small and it would give a long chance for the child to live, why are we going to court? Why shouldn't we mediate that dispute, right? And some are legal, some are non-legal, and what you do is you're looking at your society and saying, what skills do all people need? Because we think of leadership as different and something else is different. All these skills, and they put mediation and conflict management and conflict resolution as basic skills that should be taught from school upwards. So they've taken an anthropological, societal view of these skills and said, it's not preventative, it's not resolution, it's just what you need because life will throw you curveballs. And do you know how to deal with them? And then life will throw you leadership opportunities, and do you know how to deal with those? So I think we're moving, and there is a realization around the world that these skills are not legal skills. This is not a lawyer adding a skill to their bow. This is not a CEO handling conflict skills. These are skills that should come from day one, from the moment you're born, all the way across. And there's a great book, if I can recommend it, about how to teach children about resolving disputes. And the book is called Trouble at the Watering Hole. It's about animals that need to all drink at the same time and how they figure out without getting into a dispute. And I think we need more of those kinds of books. We need those kinds of lessons to be part of life. And I can see some progressive governments looking at mediation not only as a backlog buster or a online dispute resolution future, but as something that your society will use to be better, empathetic, connected, all the skills that we want, but in a way that doesn't say it's only through the lens of law or something else.
Powerful ideas there. What I understand is that right from schools, as soon as we start learning probably maths, history, geography, languages, we also learn conflict resolution, conflict management as a subject itself, along with there being peer mediations in schools with children actually playing that role since childhood, it then imbibing into a way of life. You also spoke about a line that really resonated with me, which said that only recently mediation has been hijacked by the legal community. I think that sums it all up, that mediation has not so much to do with law as much as it has to do with life in itself. So, a lot of powerful ideas, definitely a lot for us to also look at, explore, and see how we can implement it in our societies also. And based on that, I'm going to hear from Tanu ma'am now on this aspect, which is that you're a lawyer, you're a teacher, you're a mediator, you're a mentor. I've personally experienced you in all these forms, roles that all involve negotiation and dialogue and mediation. If we begin to treat mediation not just as a profession, but as a form of emotional intelligence and communication literacy, what kind of social and cultural transformation can we expect?
I like this whole the direction of the conversation, and the fact that finally we are accepting that communication literacy or communication education is equally an important education. Just some time back, I spoke at a place where I said that as a lawyer, I was trained to communicate without emotions, like all of us lawyers are, like all of us in the modern corporate world or any world, business world. We are trained to be emotionless, right? Because we think that it is without our emotions that we can be rational, that we can, put our point well, and we can focus on our goal. There's a huge shift in world understanding now. So, what was acceptable maybe 50 or 100 years ago is now being trashed. And we are accepting that no, emotions are the core of our world. Because it's so easy to be emotionless, then we are just a robot, right? So, our focus on being emotionless and focusing on rationality has ultimately led us to this new world of robots. And suddenly we realize that, oh my God, we don't need to be like them. I mean, we need to be ourselves, which is emotions. So now coming back to communication of emotions, the ability to communicate emotions without getting destructive is a prime ability that all of us need to develop. Because the minute we are destructive, we will go into conflict. If we are able to manage and express our emotions well, not trash them, not put them on the sidelines, but manage and express them well, we can move to a world which is better communicative and more empathetic with each other. Because when I understand your pain, if expressed rightly, without anger, without angry expressions. See, your pain is pain, your anger is your anger, but the way you communicate can trigger my anger or my emotions. So the ability to communicate well is the ability of being a social being, a good human being who's a social being, and human beings are social beings, right? So once we are able to focus on that, that can come in right from the beginning in our childhood, through our schools, through our education system. Okay, it's not only about math and science, it's about communication, and communication is not flowery language. Communication is the ability to evoke emotions that are positive. I mean, eventually we have to teach children that your communication has to be a communication that will evoke a positive emotion, right? While expressing all your negative emotions, it is also important that the goal is positive emotion, which can lead, us all to ride out the wave of conflict. So I'm glad we are talking this language now. I'm glad that we have come to this new worldview, that eventually communication skills, which we are learning in mediation, are life skills, and they need to be taught right at the primary level, so that we have better citizens who are able to communicate to each other and who are able to prevent a conflict rather than, going full way down the road and then ending up in courts and dealing with each other.
That is so beautifully put. I understand the difference between robots and humans is that EQ, is that emotion factor, and how we can use emotions in a positive way to communicate what we are feeling without them being destructive. And thank you for highlighting the power of three E's, which is only unique to humans. That is emotion, that is empathy, and that is expression, and how they can become powerful tools as a life skill and help us mediate our way through life itself. And on that note, thank you for sharing your insights today with us and taking time out to spend the evening with us. This has truly been a unique digital knowledge exchange. It's clear from today's conversation that while mediation may take different forms across different jurisdictions, the underlying value still remains the same: respect, dialogue, empathy, and resolution. I think we've not only explored themes that we set out to discuss, but also uncovered new perspectives, new ideas, new techniques that can truly shape the way we think about mediation from now on. At this moment, I'd like to take a few questions from the audience. I'm just going to read them out, and please feel free to answer. Anyone just feel free to unmute and answer. The first question is that in India, even with court annex mediation and the push towards pre-litigation mediation under the Mediation Act 2023, a key concern is the enforceability of mediated settlement agreements in purely private mediations. How can legal tech tools be leveraged to make enforcement more seamless without diluting party autonomy or confidentiality? Any of you would like to answer?
I'll have a go. So
Sure.
this is Anand's question, right? About the enforceability of mediated settlement agreements, right?
Yes, yes.
Look, any law on mandatory mediation will be negligent if it doesn't deal with the enforcement. Okay. And I have some understanding and some experience of the Greek law. And I think it's also similar in other parts of Europe as well. But one of the things that it does is once the agreement takes place, it must be filed in the court and effectively becomes a court order. Or in the UK, we would use that as a consent order or a Tomlin order, as we call them as well. And I think this idea, and I'm just going back to the question, Manav, about key concern in private ones, is that you cannot have a two-tier system. So you cannot have private mediations being dealt with separately and the court ones being dealt with better, right? We want to encourage the private market. And this is why the UK is going to the PAP model, the pre-action protocol model, which is nothing is in court. Everything is pre-court. You don't file in court and then you go to court, but we'll regulate how that works. So I think that the Mediation Council, the government will really need to look at not creating a two-tier system where one is weaker and one is stronger.
Understood. Encouraging private mediation, giving it the same validity as, let's say, court annex mediations is one way definitely to go about it. Tanu ma'am, would you like to add anything? You're muted.
I also think that in India, given the fact that execution is so slow and so difficult, mediation actually is an open option to continuously engage into, so that people need not be forced into execution. It should be a commitment. Mediation allows you that. In a court system, you've got an order, you have to execute it. Certain problems have come up with one of the parties, okay, and they have backtracked. They are not respecting the mandate or whatever commitment or whatever order has come in, right? So there is a problem, which is which is preventing a party from implementing it. That problem could be anything. It could be deliberate, it could be a doubt, it could be, some genuine technicality, whatever it is. If you are in a mediation, one can be talking again to the parties to understand what is it that's blocking the execution and then taking it forward, right? If it's in a court, no, you'll again have to go through proceedings. So mediation actually gives you the option of opening talks again and ensuring that the party which has agreed to executing or following certain terms is committed to doing it, maybe with a little more flexibility. So eventually, I feel that it's not your technical regulations that will work. It will be the ability to communicate with the parties and understand what their blocks are that will remove the bottlenecks to execution.
Yes, very well put. Thank you.
And I'd just like to add, there was a matter I've just completed. It's been under settlement for 4 years. And
Okay.
that's beyond everything and anything that even I have done. 4 years is beyond even what the law mandated mediation says. But there were bottlenecks in execution, which is why parties weren't committing. And luckily, the other side understood that too. So rather than getting angry, the other side simply agreed to flow a little, go ahead with this slowly, wait for the bottlenecks to clear out, and eventually got an ensured agreement. So I think it's communication again.
Yes, absolutely. I think the essence of mediation being voluntary consent solves most of the problem. With respect to challenges in execution, legal tech is also playing a role there, definitely. Of course, not for all disputes, but many kinds of disputes. One of the examples is having an escrow mechanism. For example, if a dispute does have some sort of a settlement payment term, it simply could be done by way of an escrow to ensure that parties are fulfilling their obligations, conditions attached to each payment is executed and well taken care of. That is a role that some legal tech tools can also play to ease out the enforcement bit, whether these are private mediations or court referred mediations, and that is also evolving definitely. I hope that answers your question. The next one, Rahim, I think would be for you, which is that if someone is opting for international mediation as a career option, where most of these would be online, what are some of the important things that mediators should keep in mind?
Very, very good question. Look, I think the skills of being a mediator, whether you're national or international, I think are the same to a certain extent. If you're going to hold yourself out on the international scene, I'm a big believer in making sure that you have really, really high levels of emotional intelligence in cross-cultural communication. Okay? Because we need to understand that you may be mediating in the Middle East, you may have a client from North America and another client from parts of Asia. And that brings triple challenges plus your own baggage of your own culture.
Yes.
Right? So this can become quite scary. And so I see the ones that do really well internationally, they become international in mindset and language. In mindset and language. You will see international mediators don't use colloquial language regularly, right? They will start to create a vocabulary that is internationally accepted and communicate with clarity that allows parties from whichever jurisdiction to be understood and for them to understand you. So, number one. And two, accepting that parties from different parts of the world with different language, interpreters and lawyers will approach a negotiation or a mediation in totally different ways, and you will have to be the master of process to level that. So I never see diversity as a weakness. Diversity is a strength if you know how to manage diversity. Okay, so I think, but the skills of being a mediator, whether you are in India, you're in Turkey, you're in the UK, you're in another part of the world, those are universal. It's the communication and understanding and having that huge, huge understanding of EQ, high levels of EQ will help you.
Yes, absolutely. And I think I've learned from you and Tanu ma'am both the importance of researching on culture of the parties also before entering that mediation room, something I've learned from both your trainings. And I think that's what presents a unique opportunity for international mediators also, because not everybody thinks about that. They only think about facts of the case and strategies that can be used, not the cultural element or looking at mindset and language also being global and acceptable to all. So, next, with that, I'll move on to the next question. Tanu ma'am, I think this could be for you, which is awards in India. Just a second. Awards in India are enforceable under Section 36 of the Arbitration Act. But what practical reforms or procedural innovation, especially if we were to leverage technology, do you see as necessary to reduce the delay and bottlenecks in execution, particularly while dealing with assets across multiple jurisdictions?
So I think we definitely need more management via tech of execution. And it could mean simple. I mean, it's not like some big rocket science. Right now, execution is handled very haphazardly and very in a regulatory manner. You do this, fill this form, then do this, fill this form. I'd rather have a very corporate approach, which is basically have an Excel sheet, steps, and tick marks, all right, which can be shared with all parties, which is possible via tech, right? That this has happened, this is yet to happen, the next step is to take place, and maybe a little column, why, what is it that's blocking. So tech helps you make better communication, have better communication. Tech helps you connect with people and allows people to connect and kind of log into you about what is happening, why is this taking time. And eventually, execution, which otherwise in India, I'm now specifically talking of India, which takes a lot of time simply because there is so-called red tapeism in everything, or there is there is no communication, which leads to doubts, which leads to all kinds of presumptions that can be obviated. So I think tech is a very, very necessary and important intervention right now uh, for executing decrees or awards or even settlement agreements under mediation.
Yeah, sure, we're definitely moving in that direction also. So we'll see that easing out as we go along. Next question could be for all of you, which is that which talks about language as a barrier, which is that let's say your communicating language is one language, but let's say parties come from all different language backgrounds. In that case, how do we break the cold culture barrier so that parties can understand that even if the mediator has a different native language, they will still understand their dispute and understand their point of view in a proper way? So, how do we make parties comfortable just than basic greetings in a language in which they understand, especially where the mediator and parties all come from different native language backgrounds?
I can kick off on this one. Look, I think this is a real problem in mediation, right? And I've seen this. And first thing to say, and I think we all understand this, is mediation is so nuanced that you don't want things lost in translation. Okay? You don't want things lost in translation. So that's the first thing. The second thing is about the ability to communicate with clarity and in a neutral tone and language for others to understand that second language. And the third thing, and I think the way the question is being asked, and this is a bit of a challenge, is if the person feels that's communicated, that they're not being understood, that's the problem. It doesn't matter which language, you can be speaking the same language. We could all be speaking English. We could all be speaking Hindi or Turkish. But if you're communicating in that language and you feel the other person doesn't understand you, it doesn't matter what the language is, because the block is the perception that I'm not being heard. And so a key skill of mediators in any language and multiple languages is that the party communicating must feel heard. And if we can't do that, then we shouldn't mediate.
Understood. Matzo, would you like to add anything on that?
Yes, indeed. Actually, yeah, language barriers are happening all around the time in arbitrations, in mediations, but as soon as you make the other parties feel that you're understanding, you can show this emotion, you can reassure that you know the facts of the case, you can establish that communication. Maybe you can, like, in that type of case, more inclined to write. I mean, writing is a powerful tool as well. So there are many ways, different ways to show that you're pursuing the other side. So yes, it is at the end of the day a barrier together with the accent and as well and everything. But still, at the end of the day, it's all about the other party realizing that you're actually there for them. That you are actually there for both parties. And at the end of the day, some people who don't speak the language very well are better mediators than the ones that are just like sleeping around and not paying any attention.
Yes. Tanu ma'am, anything you want to add then? You're on mute.
I think both the speakers have said it so well, and they have covered the issue of why language doesn't matter. Maybe one thing, I want you to know that I want everyone to remember that even silent movies of Charlie Chaplin touched us all. There was no language. So, like Rahim said, you could speak the same language and yet you wouldn't be able to understand. So, it's a matter of uh, uh, building that ability to be perceived correctly.
Absolutely. So well put. I think the idea is not that we need to manage language, we need to manage the emotion that parties are feeling. Language is just a medium. Thank you for sharing those wonderful insights on this persistent question about language being a barrier, which clearly isn't. We just need to change our focus. Out of respect for time of everyone, I'm going to take one last question. Again, something that any of you may choose to answer. Very interesting question, which is that in the question is that many believe that in the long run, one can either be an exceptional lawyer or a master mediator, but not both. Given the distinct mindsets, and as Tanu ma'am, you also mentioned that as lawyers, we are trained to talk without emotion, whereas mediation thrives on emotion. And even so, there are distinct mindset skills and even ethical postures that are required. For young legal professionals in India who want to excel in both litigation and mediation, is it really realistically sustainable to maintain that dual track, or is it essential to choose one path early to truly master it? Tanu ma'am, would you like to go first?
Okay. So I'll put it this way. If there is a certain, give me a minute. I'm trying to put this in a way that can be acceptable. If there is a certain issue that requires addressing, and that address is not put out in a way that helps everyone feel connected. If it is put out in a way that people feel completely disconnected and off track, where does the fault lie? Is it in the communication, or is it in the person who's communicating, or is it in the overall, what we say, the overall situation? So there are plenty of factors that kind of, work into building a proper mediation. And I would think that it is better that we look in ways that everything can be managed. Personally, I was of this view that you cannot sail in two boats. Okay. But over a period of time, I have realized that you have to at least aspire to be so detached that you can be in two boats. I mean, in Indian mythology, we have plenty of so-called, heroes whom we can look up to, who have lived both as a great warrior and a great mediator. So at the end of it all, whether you are a great litigator or you're a great mediator will depend on your ability to change roles and change your ability to address situations in different situations. Initially, yes, you feel, no, I can't do both. It's like saying, oh, I can't be both a good, a good worker and a good mother, For example, I may feel I am too bothered with career and I can't really be a good mother. But as you grow, you recognize that you can do everything and you can do it together. You just have to be better managers. So it's the same way with litigation and mediation.
Oh, that's so well put. Thank you for sharing that. We can do it all if we learn to manage ourselves. Anyone want to add anything on that? Okay. I'm sorry I cannot take the other questions, but we'll definitely figure another way to address them for sure. And before we conclude the event, we would like to talk about one aspect that Tanu ma'am, you spoke, Rahim, so something that you've been involved in doing also, which is with respect to trainings and how that can change the way disputes can be resolved across. And on that note, I would want to highlight about the online dispute resolution course that is offered by Presolve 360. This is a comprehensive e-learning program that covers all aspects of online dispute resolution. It also includes real-life case studies, interactive modules, and skill-building exercises that will help you learn how to resolve disputes effectively and efficiently in the digital age with practical experiences. The course is recognized by ADR ODR International. It is also certified by Justice B.N. Sri Krishna, former Supreme Court judge in India, and also has a master class by Tanu ma'am. This course is perfect for anybody who is interested in learning more about online dispute resolution. You can sign up and use the code displayed on the screen to begin your ODR journey. But with that, today's discussion reminded us that mediation is not just a legal process, it's a mindset. It's about listening more than speaking, understanding more than judging, and building bridges rather than building walls. On behalf of everyone, thank you for joining us. Once again, thank you so much, Tanu ma'am, Rahim sir, Matt sir, for spending this time with us and candidly sharing your thoughts. Thank you for all the participants who came together. Let's keep this dialogue alive in our communities, in our workspaces, and in our personal lives because mediation is a life skill. The true success of mediation is not in the agreement signed, but in the relationships that we strengthen along the way. And we look forward to hosting you for episode 2 of Legal Tech Unfiltered very soon. Thank you so much. And I would also like to thank Resolve 360 team members who've organized this very, very well. Thank you so much, everybody, and have a lovely rest of your day.
Thank you. Thank you so much. This was such an interesting conversation.
Thank you.
Thank you, everyone. Have a great day.
Thank
you,
you.
Namita. Thank you, Tanu. Thank you, Mustafa. Lovely to be with you, and to all the people that were listening, thank you for joining us as well.
Thank you, and we will see you soon.
Thanks.